In Boise, Idaho, in October of 2021, there was a mass shooting. Several customers were shot and seriously injured. One customer was shot and killed. And as well, there was a fatality of one of the mall security guards. OSHA came in after the violent event and conducted an inspection consisting of interviews and then issued a citation against the firm that provided mall security, alleging that that firm, Professional Security Consultants Incorporated, had failed to adequately ensure the safety of its guards. We're going to talk about that event, the citations, OSHA's allegations, and the administrative law judge's decision. I'm Manesh Rath, and this is the April 2025 episode of the OSHA 3030. Hello, everyone, and welcome to the OSHA 3030. I'm Manesh Rath, and I'm an attorney at the law firm Keller and Heckman. And for 30 years, I've represented management side. I focus my practice in the field of occupational safety and health law. I'm joined today by my colleague and friend, Ben Idzik. Ben, thank you for joining us on the OSHA 3030.
Always a pleasure to be here, Mon. Thank
It's
you.
my pleasure as well. Thank you. And I think we've got a great topic today. I think it's an important topic. It goes to the question of OSHA's ability to regulate violence in the workplace, and not just in specific segments of the employer sphere, but as well the entire general industry, including a retail facility or establishment like a shopping mall. So why don't we get into this particular and I think incredibly interesting case, the Secretary of Labor versus Professional Security Consultants Incorporated. Well, I think we should start with giving a background and the facts of the case.
Right. We'll start with those, and then we'll give a brief overview of OSHA's history on the position of workplace violence and how it regulates it.
Yeah, it hasn't been consistent over 40 years as it has evolved. I think it's actually revolved around and gone back and forth a little bit. This is at the moment, and since 2019 at least, it has been something that OSHA has believed falls under the general duty clause. So I think just for the benefit of our attendees on the OSHA 3030, we ought to make sure that everyone knows what the four elements are that OSHA has to establish when alleging a violation of the general duty clause.
Right. And from there, we'll get into OSHA's allegations, the arguments that they made in this case, and also the ALJ's holding in this case,
Which is,
interesting.
yeah, the important part, right?
Right.
And I think that's what makes this case so interesting is how the administrative law judge felt about OSHA's allegations of a violation of the general duty clause. And finally, as we always do, we're going to wind this up with some practical takeaway items for our friends in the OSHA 3030 community on a slide titled What Employers Should Do. So with that said, Ben, why don't we get into it? Let's talk about the facts of this case.
Right. So the facts in this case centered in Boise, Idaho, at a mall on the west side of town. The mall houses about 130 boutiques and several anchor stores, popular favorites like Apple, Macy's, Lululemon. And the owner of the mall, he engages a security firm called Professional Security Consultants, PSC, to provide security for the mall. And as part of that, provides about 3 or 4 guards that staff the facility throughout the day and also night guard.
That's right. The owner of the property is Brookfield Properties. They own many malls throughout the area, and they engaged professional security consultants to provide security. I think it's actually a leanly staffed operation. There's maybe one dispatcher who's watching monitors, and then there's two security guards who are patrolling the mall at any given time. But on the night shift, it's just one when the mall is closed. It's just maybe sometimes one overnight guard. So I would say, given the size of the establishment, that this is a leanly staffed security operation. And I'd also say one more thing that's important to understand, and that's that the anchor stores are not a part of the jurisdiction or the contracted territory for the security guards. They are essentially there for all of the mall except for the anchor properties. So now, Professional Security Consultants Incorporated is engaged in the patrolling, and one of the rules for the mall is that patrons, customers, are not permitted to bring firearms onto mall premises. And the guards, as part of their onboarding, they are provided training in de-escalation tactics. So some of the issues that they deal with, in addition to shoplifting, are things like altercations and active shooter events. They're properly trained on those as well, and they're trained on this policy that there's a ban on the premises for bringing firearms or other dangerous material onto the mall premises. And the guards are trained on how to deal with each of these issues.
Right.
And they I think the other thing that's important to point out is that they are trained on how to engage in encounters with patrons, with mall customers, in order to deal with these issues, and when to disengage and when to contact law enforcement. One more thing I think is important to point out, Ben. The guards at Boise Town Square Mall are not provided with firearms themselves. They are unarmed. They're also not provided with bulletproof vests.
Right. I think at most the officers were provided with pepper spray, but like you mentioned, no firearms that they had, and no any sort of protective measures like vests. I think the interesting part here is that this takes place, like we mentioned, in Boise, Idaho, and in Boise, open carry of firearms is permitted. So when this mall policy was violated, in some occasions, the security professionals would call Boise law enforcement, and Boise law enforcement would generally not respond to those calls, meaning they wouldn't come out unless there was some kind of intervening criminal activity that was taking place in addition to the open carry.
That's right. Some kind of unruly behavior or
Mm.
shoplifting or an altercation of some sort. Then they would come out. But they received many calls from the Boise Town Square Mall security company, PSC, and they said, "Look, this is well, if all they're doing is carrying a weapon in an open carry state, then we're not going to come out and respond to all these calls." But maybe that is a questionable decision, because essentially what has happened is, if the mall has a rule banning firearms on its premises, then anyone who violates that rule is essentially trespassing. And if you asked the Boise State Police whether they would respond to a trespassing call from any other private property owner, maybe a residential homeowner, I think the answer would be yes. If they got a call for trespassing, they would respond to it. It is merely because the fact that creates a trespassing event is that they are entering the premises with a firearm on a premises that bans firearms, that they had taken the policy, that the police department had taken the policy that they wouldn't respond to that variety of trespassing call. And I think that that is a debatable decision on the part of a municipal police department. And it may be that they've changed that policy since, or that they've persisted in that policy. But that becomes a central fact as OSHA makes its arguments to the administrative law judge.
That's exactly right.
Okay, so now around June of 2020, Jacob Bergquist, a resident of the area, had already become well known to the mall guards employed by PSC. Because what would happen, he had developed a pattern of entering the mall wearing an openly patent or openly observable sidearm. And mall guards, either they would notice this at dispatch level on the monitors and send a patrol guard to interact with him, or the patrolling guard himself or herself would notice that Mr. Bergquist was walking around the mall with a openly observable sidearm. And so what would happen was that the guards would approach him and inform him of the mall's ban on firearms.
Right. And like you mentioned, this happened on several occasions. I think OSHA asserted in their arguments that it happened around 10 times. I think the LAJ concluded that based on the evidence, it happened at least 5 times. So many occasions.
From June of 2020 to about October of 2021.
Right.
So over about a period of 15 months.
Right. Right. So like you said, this person was well known to the security folks at this mall, and generally when these interactions were to occur, he would comply. He sometimes would quibble about Second Amendment concerns, but generally he followed the officer's instructions pursuant to mall policy, which was, if you're in violation of this no firearms policy, you're required to either go back to your car and leave the weapon in your car, or leave the mall altogether.
That's right, Ben. And he had this strange story as well. He would, first of all, he would quibble about his rights to bear arms under the Second Amendment, which,
Mhm.
as we all know, does not apply to a private property owner's ability to ban anything that they want from entering their own property. That is a restriction on governmental trespasses upon the authority of the rights to bear arms alone. But he would make that argument, but then he would also say that he would inform the security guard that he was a convicted felon and that he was working collaboratively with the Boise police to see how people would respond to a former felon walking around with a firearm.
Mhm.
The story is incredible on its face. It's unbelievable on its face, but the mall security agency, PSC, nevertheless contacted the Boise police just to confirm or validate that story. And the Boise police predictably informed them that they were aware of no such program and that they didn't engage Bergquist to engage in any kind of conduct.
Right. And in addition to that, I think he also exhibited other sort of disturbing patterns of behavior with these things that didn't amount to a full-on confrontation, but he was on a couple occasions shown to be carrying more than one firearm, for example, or carrying extended ammunition, or I think a suppressor on one occasion. So this was definitely an individual who was not just sort of a run-of-the-mill person who was even carrying a firearm openly pursuant to the law.
So this type of encounter that you've just described, Ben, it went on for a good 15 months. It occurred many times with many different security guards. And one of the problems is that new security guards might have come on and not been aware of the history with Bergquist. Others may have had a longer tenure and have found him to have been a familiar feature of the mall scene and had encountered him or approached him on several occasions. So there was a variation in the experiences of the varying guards who had encountered him. And then one day in October of 2021, this is when the unfortunate mass shooting occurred.
Yeah, it occurred October 15th, like you said, 2021. Berquist was observed being in the mall's food court, and pursuant to the policy, an officer um, uh, observed this notified her dispatch radio, and then approached Berquist and informed him of the policy against firearms. Interestingly, she didn't recognize Berquist from prior interactions. And after they had a brief conversation, both parties turned around to walk their separate ways. And tragically, Berquist turned around, pulled his firearm, and then shot the officer as she was walking away.
He released several rounds and it struck several customers, seriously injuring them. And it
Right,
also not only killed her, the security guard supervisor, but it also killed one of the customers, one of the patrons of the mall,
right.
and seriously injured several others. OSHA came on site, probably as part of a referral with law enforcement,
Mhm.
and conducted an investigation consisting of interviews with several witnesses, and then issued a citation to PSC under the General Duty Clause,
Right.
which I think the idea of issuing a citation to the security firm all by itself, to me, generates a great deal of interest as to why OSHA thought that one of PSC's security guards, having been shot and killed, qualified as an OSHA violation. Is a question of tremendous interest to me. What their thinking was. So why don't we go ahead and talk about what OSHA's allegations were in this case? Well, I think to begin with, in order to understand the allegations that OSHA made in their complaint before the administrative law judge, probably it's important to understand OSHA's position on workplace violence as it has evolved since 1970, the enactment of the act. For decades, and for the first 2 decades of my practice, I thought that their position was consistent as articulated in a compliance directive that said OSHA said that it found workplace violence to be inherently unpredictable in nature and not occupational in its causation, and that it was best left to law enforcement, and it was not an appropriate area of enforcement for OSHA. This changed somewhat in 2017 with the development of the 2017 Field Operations Manual, and that instance, OSHA stated that there were, in fact, some industries where workplace violence was sort of occupational in nature, or that the industry or the occupation was such that it had its own history of repeated patterns of types of violence, that those patterns of violence could be reasonably foreseeable according to OSHA, and that there were steps that employers could take in those specific sectors that could minimize or eliminate workplace violence hazards. It believed at the time of the Field Operations Manual of 2017 that late night retail in certain locations, as well as social services and healthcare, particularly with regard to mental health care and correctional facilities, particularly privatized correctional facilities, were examples of specific industries where workplace violence was a repeatable, observable pattern that uh, could be minimized or eliminated with some precautions that were well understood in the industry. That was the position starting 2017. But they didn't promulgate any standards at that point. By 2019 onward, OSHA had begun to use the general duty clause, but to my understanding, to the cases that I've seen come across my desk, they had only done so. The agency had only used the general duty clause with respect to allegations of a violation of the general duty clause with workplace violence as the hazard with respect to healthcare facilities, and specifically social services or mental health care facilities. And that's consistent with the very narrowly tailored position that it had announced in 2017 in its field operations manual. Integra Health Systems is probably the landmark case, and that describes the evolution of OSHA's position from recognizing the inherent unforeseeability and the lack of work relatedness of violence itself to 2019 and the Integra Health Systems case, where at least in certain industries and in certain professions, maybe OSHA felt like it was reasonably foreseeable and that there were some abatement measures that could be feasibly implemented.
Right.
So it started using the general duty clause.
Exactly right. And the general duty clause comes straight out of the OSHA Act. The OSHA Act provides that each employer must furnish his employees with a place of employment that is free from any recognized hazards that cause or can cause death or serious injury. And there are four elements that in a general duty clause citation, OSHA has to prove by preponderance of the evidence. The first element is that the condition exposed workers to a hazard, meaning they created the hazard or contributed to it.
That's right. And the second one, and this is a really critical one. In fact, the first one that you mentioned, Ben, seldom becomes a issue of contention between the parties. The idea that there was a hazardous condition that employees were exposed to is seldom in general duty clause cases what our administrative law judges turn a decision on. But the second one is critical. The idea that a hazard being alleged by the Occupational Safety and Health Administration was in fact recognized as a hazard by the employer or by peer employers within the industry is an interesting question, and particularly of interest in the field of workplace violence.
Exactly. And the third is that OSHA has to provide enough facts to show the likelihood that the hazard could lead to death or serious harm. I think when these citations come before ALJs, this is where a lot of fact weighing takes place to determine if that was indeed the likelihood.
Right, and it seldom is the issue that the administrative law judge turns a case on in general duty clause cases. It's also one of less importance in the analyses applied by judges if you look at the larger volume of general duty clause decisions that are out there. And then finally, and I think this one is actually also of intense scrutiny by judges, was there an allegation by OSHA that there was a feasible means of abatement that could have corrected or addressed the alleged hazard? And the reason why this is of great importance in this particular case is because OSHA, in its issuing of a citation against PSC, did identify four measures that it thought PSC could take going forward that implicitly OSHA is alleging would address the hazard of workplace violence. Okay, well, maybe to start off with an understanding how it applied those four elements, we ought to talk about OSHA's allegations in this particular citation.
Right. OSHA began with the position that PSC should not have allowed guards, its officers, to even approach individuals like Berquist. They assumed that, or they argued that based on his prior conduct and folks like him, they should have known that he posed a hazard.
This is an interesting allegation, Ben, because what they're saying is that they acknowledge implicitly that the security guards should have approached Mr. Bergquist the first time that they saw that the guards saw a violation of the firearms ban, but that they should not have approached him a second or third time. Implicit in that allegation is that if somebody violates a firearms ban and walks around with firearms, it is safer for the guard to let him continue to do so a second or a third time, but it is perfectly safe for the guard to approach the person the first time. And that if somebody just refuses to comply, then just let them have their way. That essentially seems to me to be, in between the lines, the view that OSHA is taking here. The four abatement steps that OSHA alleged that PSC could take in the future were: first, OSHA argued that PSC could develop a workplace violence program.
Right. And then second, OSHA said that PSC should implement a more effective system to track repeat offenders. I think they took issue with some of the policies that they had in place, as it were, during this incident that didn't adequately.
Well, what they're specifically saying, Ben, is that the guard who comes up on Mr. Bergquist one day should have known that some other guards
Right.
had approached him maybe a month, 2 months, or 6 months earlier, and that the PSC had done a poor job of creating a tracking system or a log
Right.
that somehow, according to OSHA, when a patrol immediately observes somebody with a firearm in violation of their ban, that they should consult a large database without having any identification of that person's name. Indeed, the judge noted that the guard had no right to stop them and demand identification. So somehow, merely on sight and on facial features, I suppose,
Mhm.
that guard should have known something or been able to consult a database and identified this person again in the database. They never explained how that would work, and I personally don't understand how that could possibly work, the way OSHA seems to have envisioned it.
Mhm.
Maybe they're thinking that a security guard for a shopping mall has immediate access to some kind of facial recognition database, and that is, if that's what they were thinking, I think that is an absolutely incredible sort of supposition to make in insisting upon this kind of abatement. And then the third thing that they alleged should have been a form of reasonable form of abatement was that the guards should have been trained in how to enforce a policy for not approaching repeat offenders. Again, this validates my understanding of the implication that it was only the repeated violations by Bergquist where OSHA believed PSC should not have approached Mr. Bergquist. Indeed, it was specifically articulated by OSHA in this third abatement measure that they're saying you should have trained the guards not to approach repeat offenders.
Right. And then finally, OSHA said that the training that PSC did provide was not enough, and the ALJ decision did detail that PSC provided training on workplace violence to officers, but it seemed to be only take place during the onboarding stage of the officer's career. I think OSHA wanted to see more retraining, perhaps like annual reviews of that training as it
That's
went.
right, Ben, but they didn't allege that the training that was provided was somehow inadequate.
Right.
And so without that missing component, I don't know why they concluded, we don't have any understanding as to why they concluded that training was there, but additional training was better. I think that you need something to connect those two suppositions.
Right.
So the administrative law judge looked at the facts of the case, looked at OSHA's arguments, and the first thing it said was OSHA had not offered any guidance as to when an interaction with a mall patron would fall outside of OSHA's jurisdiction. When does OSHA have the jurisdiction to regulate workplace violence in general industry employers that aren't these specific sectors like correctional facilities, mental health institutions, et cetera?
Right. And I think to that point, one of the things that the ALJ focused on and in fact cited to, was the decision by the Supreme Court involving the COVID-19 mandate being administered in OSHA. The ALJ said that OSHA does not have the jurisdiction to regulate sort of day-to-day hazards, and it attributed the risks of that occurred in this case of an active shooter as a day-to-day hazard in the general industry setting.
It was a hazard. That's right. The administrative law judge said this is a hazard that is sort of extant in society generally, and it is not a hazard that is formed uniquely by the workplace. And so OSHA is really stepping outside of, or it is appropriating for itself an enlarged understanding of what Congress intended to delegate to it as its powers. And that was the words of the administrative law judge. The other thing that the administrative law judge said was that it's well recognized that the Occupational Safety and Health Act doesn't create a strict liability standard, that if something went wrong, then you're automatically liable as an employer for it. You have to establish that there was some kind of ability by the employer to recognize what the hazard was and that there was a feasible means of abating that hazard. And indeed, those are two of the elements that we just discussed as elements of the General Duty Clause. But that is a long-standing understanding of what Congress had intended to delegate as a power to the agency. And in following on that point, the judge said that the type of violence engaged in by Mr. Bergquist was not a legally cognizable hazard for OSHA to regulate because it was indeed inherently idiosyncratic in nature. And these inherently idiosyncratic conducts or acts by violent individuals is not within the scope of an occupational hazard, such that A, OSHA has the ability to regulate it, or B, that it's reasonable to expect employers to interdict and eliminate.
Right. And just to finish off that point, Manish, I think it's interesting that the ALJ noted that, on the prior interactions that the officers had with Bergquist, he didn't while it was disturbing and strange, he didn't indicate to them that he would pose a mass shooter threat.
Well, that's right. OSHA argued the opposite. They said his behavior was just weird and bizarre, and so that should have been a clue not to interact with him anymore. And that's just not true. The judge said, no, in fact, the interactions with him every single time prior to the shooting were that ultimately he walked out, he left the mall peaceably. Even if he argued about his Second Amendment rights or told this bizarre story about being an affiliate of the police department, nevertheless, he turned around and walked out of the mall. And not to return maybe for perhaps like a month later. So that was the opposite understanding of the facts by the judge as from OSHA, and that in fact the history of Mr. Bergquist's behavior would have not given a reasonable person in the position of PSC's guards a reason to believe that somehow he was inherently dangerous, or that this 11th time, for example, it would have spontaneously erupted in violence.
Right. Exactly.
So as we said, OSHA, the administrative law judge said that the Occupational Safety and Health Administration did not have authority delegated to by Congress to deal with hazards like a mass shooter. It was outside of their authority, and that public places, when you talk specifically about public places, the risk of violence is not occupational in its nature or in its causation. And there's nothing about violence that's particular to the workplace. Ben, as you pointed out, that is the analysis that the U.S. Supreme Court handed down when OSHA promulgated its proposed standard involving addressing hazards associated with COVID.
That's right, Manish. And then in addition to that, the ALJ, I think, pointed out that the PSC did have a system in place to protect against potential hazards. We mentioned at the beginning some of the training that they provided to officers, the SOPs that they had that addressed active shooters. While these things were not exactly to OSHA's, to what OSHA believed should have been the system in place, the ALJ did see that there was indeed some measures that they had in place.
Right. And I think that the implicit in that is that there's no reason to believe that the system that they had would have been inadequate, or that any other system would have prevented Mr. Bergquist's act of violence. And until there is some way of knowing that these additional measures proposed by OSHA would have actually prevented, additional training would not have prevented Mr. Bergquist's violent act. And until there's any way of knowing what steps would have, then it's very clear that the General Duty Clause cannot be used to enforce absent of feasible means of abatement that would have actually had an abatement kind of effect. Okay, well, in light of the administrative law judge's decision, I should point out the obvious by now that he dismissed the agency citation against PSC, and I think his reasons were very reasonable and sound bases for dismissing the agency citation and saying that this is way outside of the scope of the general duty clause. So in light of that, let's talk about what employers should do.
Right. I think it's important, like you said, Manish, that even though the citation here was dismissed, there are plenty of takeaways that we can learn from.
Yeah, I think that's right.
Right. I think the first thing that came to mind is just to ensure that employers are conscious and evaluate the historical patterns of workplace violence in and around their work site. So this includes analyzing things at your actual facility or establishment in the neighborhood in which the facility is, and for similar experiences of counterpart employers in that area.
Yeah, I think that's right, Ben. And again, as you say, it's important to note that what we think employers could do is not to say that we think that the general duty clause would apply, but that these may be reasonable measures that could be taken anyways, above and beyond one's legal duty. And these three that you just mentioned are consistent with the specific industry sector that OSHA had opined would maybe be covered under the general duty clause, and that's late night retail establishments. This was not a late night retail establishment in a particular location that had a history of violence. This was a shopping mall right in the town center. But nevertheless, employers with public spaces could develop some kind of understanding of what the patterns of violence are in their own neighborhood and with other similarly situated employers, malls in other neighborhoods, and what steps they're taking. I think that that is a simple step that employers could take. And maybe there's some measures that I'm not asserting that the employer needs to take as a question of law, or that they would eliminate violence by any means, but that they may have some kind of reductive effect on the impact of a violent event or on the frequency of violent events, et cetera.
And then similar to that, I think it's important to double check that they're in state plan states where there may be more stringent standards or other guidance that are issued for that specific state. So just our recommendation would be to ensure that the local states, if you are in such a state, to verify that there isn't workplace violence.
That's
guidance in
right.
that.
The OSHA 3030 as a podcast was developed for providing information to clients and friends of Keller and Heckman. We know that our friends in Ohio or California, for example, already have either regulatory or statutory measures that are addressed or proposed to address workplace violence in limited sectors. And so if you're in a state plan state, you have to consult those state laws and check with your OSHA counsel. We would be happy to help you answer that question for your own establishments. And in addition, we know that OSHA has talked about developing in the field of healthcare, a workplace violence standard. It's been in their discussions for years. So that's an excellent point you raised, Ben. And then finally, I think that one of the things employers can do is develop training programs as PSC did. I think that they had a great training program, and the training program should include how to identify potential hazards, how to report threats, how to handle emergencies, when to consult with law enforcement, and when to notify other workers or other public patrons of the premises if a threat is perceived.
Right. And similar to that point, Manish, it's important to strive to develop security systems.
We're talking about electronic security systems, for example.
Exactly, yeah. Electronic security systems to ensure that that workplace violence is minimized and monitored. This includes training on these systems to employees, ensuring that the training is periodic and that there's testing that occurs to ensure the systems are indeed working, and to, like OSHA sort of advocated for in this case, make sure that it doesn't just occur on one occasion, that it's constantly being reevaluated based upon ongoing hazard analysis.
Right. As an employer learns more about what's going on in their neighborhood, they may decide to revisit whether their security system adequately addresses those kinds of incidents and whether there are modifications that could be made. And then finally, I think it's important, as PSC did, to engage in a relationship with local law enforcement and to maintain correspondences with your law enforcement agency. In this case, Boise Town Square Mall, the PSC had reached out to the Boise police, and the Boise police said, we're not going to respond to complaints of trespassing involving open carry. That kind of correspondence should be maintained, those records should be preserved because they form an important part of the history of whether an employer did what it could or tried to do as much as it could achieve in the field of reducing workplace violence and coordinating amicably with your local law enforcement agency. So I think that's critical. Excellent point, Ben. That is today's OSHA 3030. Thank you all for participating. A few notes. Our next episode will be on May 21st, 2025 at 1 p.m. Eastern Time. You can find out more information about it or register at khlaw.com. When you get the email for the inviting you to register for the next OSHA 3030, please, as I've asked many times in the past, please take a minute or half a minute to forward it on to 3 others in your own organization and at other companies to folks who are professional safety and health professionals or folks in your office of in-house counsel, attorneys responsible for compliance with OSHA law, so that the good word about the great information we provide in this program spreads and that we might be able to continue offering this program for years to come. That is a really critical favor that we're asking, and we're very grateful to you. We know that many of you have taken that minute out of your time to forward the good word about the program in the past, and we ask that you continue to think of 3 more people and 3 more people each time. And for those of you who haven't done so yet, so please start doing so. For those companies whose folk participate in the OSHA 3030, who are also responsible for complying with REACH or TSCA, we want you to know about our sister programs, the REACH 3030 and the TSCA 3030. Excellent programs by some very talented attorneys here at Keller and Heckman. The REACH 3030 will be the next REACH 3030 will be June 11th at 10 a.m. Eastern, and the next TSCA 3030 also on June 11th at 1 p.m. Eastern. Please make sure you check them out and forward them on to folks in your company responsible for compliance with REACH and TSCA. We are grateful to you for participating. We will post this program as a podcast and as well through our website. It'll be housed at YouTube. So if you missed it or if one of your colleagues missed it, make sure you inform them of that and subscribe. And don't forget to like so that those YouTube and podcast programs are more easily locatable by others. Well, Ben Isaac, thank you very much for joining me on this month's OSHA 3030. I'm thankful to everyone here at Keller and Heckman, the staff who helped make this program happen. And I'm thankful to all of you in the OSHA 3030 community who've participated for one more month. And we look forward to seeing you again next month. And until then, stay safe.